Thanks for coming along. We're back at 47 Phillip Street with a live presentation. Not that our previous ones have been dead, but we've got a live presentation here, and there are people on the Zoom call too, and it's great to have them on because some of our members live outside of Sydney or can't get here. Some live interstate, some in the country, and some just can't get here. So that's good as well. And this will go out. Will go out on our web and on YouTube and whatever. So it's great to have Catharine Lumby back at the Sydney Institute. I think it's her third or fourth appearance here, and Camilla Nelson, who makes a first appearance. So we're discussing the topic, Australia's family law courts, decisions and dilemma. Now we're going to lead off with Catharine Lumby as Professor of Media at the University of Sydney, where she studied law. She's an author of 8 books and a journalist who has worked with The Guardian Australia, the Sydney Morning Herald and the ABC, and Camilla Nelson is Associate Professor in Media at the University of Notre Dame, Australia. A former Walkley Award winner, her writings have appeared in The Conversation, The Independent, The Guardian Australia, Mamma Mia, Marie Claire and the ABC, and this is her 5th book, and I might be your 5th book as well, I think. Anyway, you're getting there. So we're going to start off with Catharine Lumby, then we go to Camilla Nelson, and then we go to questions and discussions. Thank you. Catharine.
Thanks, Gerard. Hi, everyone. And can I say it's always a privilege to speak at the Sydney Institute. Thank you, Gerard and Anne, always gracious hosts. So I'm going to... Camilla is the primary author of this book, and it's really, in many ways, her work, and I've made some contributions to it, and it was a collaboration I was thrilled to be invited to engage in. But I'm going to talk very broadly in a framing way before handing over to Camilla, and what I want to do is talk about 2 issues, one of which is a submerged issue in relation to the family court, and that is to do with children's agency, and the other is an issue that comes up again and again, and that's around the idea that men have been badly done by the family court. And I want to discuss both of them, and hopefully down the track we can have more of a discussion. So in its original incarnation, the family court, governed by the Revolutionary Family Law Act of 1975, was intended as a forum that not only operated to facilitate no-fault divorce, but equally to ensure that marital separation arrangements were made in the best interests of any children involved. Some of you here will remember the days before no-fault divorce and the terrible sorts of divorces that ensued, where people often set each other up and had PIs take photographs of them and so forth. So it was a real revolution. But I want to submit to you, and this is an area I've done a lot of research into, that who we think children are and how we understand their needs and rights is not as simple as it sounds. How we understand childhood, as historian Philip Erries writes in his iconic book, Centuries of Childhood, is social, cultural and political. It varies between historical periods. It is influenced by class and gender. Now, it's quite natural that we tend to see childhood and adolescence as they are around us, as fixed states, as periods of life where there are necessary limits on rights, agency and access to knowledge. And in practice, some of that's correct. Children are in need of the care and protection of adults. But we've seen a radical shift if we look over 3 centuries. So if we go back to the 18th century, you had the children of aristocrats who by the age of 7, if you look at paintings of the era, were posed as little adults with properties behind them. And of course, the children of the working class were sent down mines, eventually in the Industrial Revolution, or into domestic service. And we still see that around the world in developing countries. In Australia, the 20th century saw a growing increase in the age at which we understand childhood to end. At the beginning of that century, the age of consent was still, in some jurisdictions, as young as 12 years old. Now, that's pretty utterly shocking to most of us today. And of course, today we've extended the notion of childhood, or at least the protections afforded most children, well into adolescence. But when does the importance of protecting children become equally bound up with an unconscious and anxious desire to silence them? History tells us that discourses of protection are often exactly that, an excuse for controlling the voices of those the powerful do not want to hear from or recognise, or particularly those that challenge their authority, I think any parent in the room can relate to that. I can, having two feisty children. Children are in Western societies the last disenfranchised group. Corporal punishment was still used in some Australian primary schools in the 1960s in the form of the cane, and I can put my hand up. I got caned on the right hand because I was good at writing and I'm left-handed. Many middle-class 21st century parents would be ringing a lawyer if any teacher so much as yelled abusively at their child, and yet it was totally acceptable to many parents in the 1960s that children could be caned by a teacher. It's a fact that puts the way we see childhood and children's agency into historical perspective. Yet it is still the case that children's views are often not being taken into account, and their voices not taken seriously or even believed in our family courts. If you read the case law and speak to caring parents and children who have been dragged through what the lawyers routinely refer to as the Chamber of Horrors, one thing emerges again and again: children are the ones trapped in the middle. Not simply in the middle of their parents' divorce, which is bad enough. Even worse is being trapped in the middle of a system which is mired in a political and discursive minefield that can increase parental acrimony and which too often silences children. And this is a subject on which Camilla has written in great detail with many case studies in the book. In judgment after judgment, despite the best intentions of judges, children's voices are simply not being heard often enough if we think about it from the perspective of children, rather than simply the perspective of a protective adult. Now, we acknowledge that judges are no doubt trying to act in the best interests of both parents and children, and we do not pretend that it would be easy to be a judge in the family court. However, we do want to raise this question. When we think we are protecting children, are we sometimes protecting ourselves? Or to put it another way, are we protecting the idea of adults protecting children? Understanding how and why children are still silenced, disbelieved or ignored in our society matters, because it affects how they are understood by and in our justice system. And despite the old shibboleth that the law rests in the bosom of the judges, and the fiction that our judicial officers stand outside politics, that is simply not true in my view. The family court is political. It was born out of and tempered in the crucible of 1970s social and political activism, and it remains highly politicised today. Certainly, one of the biggest problems in confronting and acknowledging the issue of child sexual assault, which is something I think we're only coming to terms with as a society, and family violence, is the ongoing notion that children are fantasists who make things up or are completely prone to manipulation by a parent who plants ideas in their heads. Now, ask any child survivor of sexual assault, and I have done quite a bit of research and work in this area, male or female, and they will likely tell you how clearly and unfortunately specifically they recall their experience. Yet as recently as 1984, a former High Court Chief Justice, Dyson Heydon, felt comfortable writing in an edition of his widely used and highly cited legal textbook, in fact we used it when I was at law school, Evidence, Cases and Materials, the following about children's reliability as witnesses. Quote, "Children sometimes behave in a way evil beyond their years. They may consent to sexual offences against themselves and then deny consent. They may completely invent sexual offences." Justice Heydon's views are no doubt sincerely held, and as all, or at least his views then, I'm not saying he thinks that now, I cannot comment on that, and as all judges know, all witnesses are potentially unreliable. The question we want to ask is, why are children so often portrayed as unreliable witnesses? Why is there a persistent narrative that suggests they are likely to make things up for the sake of it, when, as most parents know well, children are often the most inconveniently blunt people on the planet? I speak from experience. What is at stake, in other words, in our refusal to take children at their word? And therein lies a potential answer to why our family court system does not let them speak for themselves, or very, very rarely. Of course, they are allowed to speak with court-appointed psychiatrists or counsellors, or sometimes those mutually agreed on by the parents, but it is not the same as hearing them in a court in a closed hearing in a sensitive and age-appropriate way. A professional report is arguably no substitute for letting children speak, because while valuable, it simply substitutes one adult proxy for their voice for another. One of the most vexed issues confronting the family court is how to deal with allegations of child sexual assault. Intrafamilial sexual assault of children is an area where it is notoriously difficult to gather meaningful data because of the long acknowledged underreporting of such abuse. Now, I think we're beginning to look at that subject. We've looked at child sexual abuse in institutions, but I think we're starting to look to the family, and we're just beginning to do that. So when these allegations come before the court, they do so in the teeth of a persistent narrative that children make up stories, and often that they do so because they have been coached by a mother who is portrayed as vengeful, deceitful, and manipulative. And there is a syndrome called parent alienation syndrome, which Camilla's written about at length in the book, which has no evidence base. And if you read the book, I won't go into this now, I don't have time, but it's certainly not a research-based theory, but it remains persistently attractive and still used at times in narratives in the court. The family court has in many ways functioned as a de facto forum for still highly politicised debates about the institution of the family and the role of children and women in maintaining or disrupting it. And I know Gerard and I'm sure Anne will remember that when the Family Law Act came in, there was a lot of opposition from the churches, and there were lots of debates, some of them very reasonable and impassioned, but nonetheless reasonable and fair-minded, and some of them not so reasonable on both sides, I would say. The important point here is that the ideological battles played out in the family court and its history concern not only gender roles, but equally how we understand the role of children and their proper place in society. The backlash against feminist attempts to expose child sexual abuse, and of course it's not just feminists who wanted to expose child sexual abuse, primarily of girls in the first instance, but if we go back to the 70s, that's when you get that narrative happening, is equally a battle over who controls the right of children to be heard and acknowledged as fully human. The issue of the way the Family Law Act disrupted traditional notions of the family, and it did, and in particular the rights of men to their wives and children. And let's not forget that women were once regarded as the property of men, of their fathers and their husbands, not so long ago, goes to the heart of another persistent narrative, that the family court consistently wrongs men, allows women to steal their children, and forces them to pay for the privilege. Many of you here will remember when in the early 1980s the family court and its judges were subject to violent attacks. A judge was shot dead and a string of lethal bombings followed. A judge's wife was killed when she opened the front door. A judge and 2 children were injured in their home. A bomb exploded outside the court in Parramatta, and a 4th bomb killed a person and injured 13 others in a church hall. It was only last year that Leonard Warwick was tried and convicted of these attacks and given a life sentence. His murderous acts were triggered by a custody dispute with his ex-wife. Despite this obvious direct assault on our judicial and legal system, one of the foundations of our democracy, a lot of the commentary at the time suggested that the fault lay with the Family Court and the Family Law Act itself. After the murder of the judge's wife, the Dean of St Andrew's Cathedral claimed in a sermon that her death had been necessary to draw attention to the court's deficiencies so that good could come out of evil. The narrative that portrays men who are violent, usually to their wives and often their children too, as a result of an adverse ruling against them in the family court as being driven to breaking point, is still far too common. In a recent Joint Select Committee on Australia's family law system, Deputy Chair Pauline Hanson repeatedly claimed that women make allegations of domestic violence to gain advantage in the family courts and expressed fervent sympathy for men's rights groups. Now, I'm going to go on and distinguish between men's rights, which I believe in, and men's rights groups or men's rights activist groups. I think they're completely distinct things. I find it telling that the language of the men's rights movement focuses on rights, their right to their children, and not on their responsibilities as fathers. Let me put what I'm saying in context. The majority of marriages involving children that break down do so in a context where both parents, despite their grievances and sense of loss, manage to come to a workable arrangement and share the care. I've been through that myself, and I'd say 60% of people my age, I'm 60, have done so themselves, and they've done it well. I'm not saying that all men think they own children and women in their lives. I definitely, most of the men I know are very good men. Or that women are always blameless in how they manage the breakdown of a marriage. Clearly not. I am saying that we still live in a society where there are visible traces of persistent myths that excuse male violence on the basis that women have provoked their former partners by stealing their children or requiring them to pay child support. Many Australians are familiar with and horrified by the frequent stories they read in the media of fathers who track down and kill their former wife and sometimes their children. And there are many of those stories in this book. As Jess Hill notes, there is a powerful narrative out there, actively cultivated by men's rights activist groups, that men who do this have been driven over the brink by a family court system in the thrall of the feminist lobby and or by vindictive mothers who will do anything to prevent a former partner from seeing his children. Now, I'm winding up here, and what I want to say is this. The men's rights activist lobby needs to be differentiated from men who, like many people who have been through the family court system, walk away feeling they have not found justice. In fact, unfortunately, that's what many people feel after they go to family court. Men's rights activists, though, in their most toxic form, fundamentally believe they have ownership rights to women and children and will prosecute their case at any cost to anyone involved. If they have money, and this is the case sometimes, they will use repeated litigation as a form of abuse. And Camilla will detail more about this, but sometimes the legal fees outstrip the assets. That is not uncommon. And we certainly go into that in the book. The men's rights activist movement can be fairly simply distinguished from movements and organisations that genuinely focus on issues affecting men, such as mental and physical health, which I support those movements. The movement's unfailing focus on denouncing women is something of a clue. Despite this, the movement has had an enormous impact on broader social perception of how divorce works in the family court, how men are treated by the court, on public policy and legal reforms and repeated inquiries. I mean, how many, Camilla? How many inquiries? Have you counted them? Hundreds. It's unbelievable. In the wake of a series of reforms instituted since the mid-1990s, the guiding principle for judges is this, that children have a right to regular contact with both parents. Now, that is a reasonable principle in my view. However, how does it operate in practice? So it's a progressive and reasonable assumption, and one that should indeed operate in normal circumstances where a marriage breaks down and both parents are responsible and loving parents. But the most complex cases that come before the family court, unfortunately, are rarely cases where both parents are reasonable and responsible former spouses or partners or parents. And this is where the real problem begins, in a system which often turns out to be the worst possible forum to hear the complex stories of vulnerable children and families. Thank you. Now I'll hand over to the primary author.
So just before Camilla Nelson comes up, I should have said at the start that this has been held on the occasion of the launch of Broken Children's Parents and Family Courts, and we'll have copies of that on sale after and also go up on our website. So Camilla Nelson.
Thanks, and thanks, Catherine. I just want to make a few reasonably brief comments. taking what Catharine has said a little further and thinking about the ways in which the style of thinking that Catharine's talking about actually works itself out in individual cases. Part of what I've been thinking about at the moment is that it's perhaps time to talk not just about children's best interests, but to talk about children's participation in making decisions about their lives, in making age-appropriate decisions about their lives. A significant body of evidence has demonstrated that encouraging children to speak, acting on children's concerns, is one of the most powerful mechanisms that we have as a society to ensure children's safety. And yet, in cases before the Federal Circuit and Family Court of Australia, evidence demonstrates that children are seldom heard. Their views are marginalised. Centrality, the central focus will always be on the claims of the parents, not the views of the child. And often in the courtroom, and particularly in the trial situation, their views will be delegitimised and trivialised, in fact. The court inadequately listens to children whose best interests it's meant to have as the paramount principle of the law. So, for my first example, I want to think about a 5-page written judgment that I came across. It was a product of a defended trial. It was a third in a series of 3 defended trials. The judge, across the 5 pages, turned his mind to whether a 17-and-a-half-year-old young man, who the judge found to be exceptionally intelligent, to be highly motivated, to be well organised, whether this young man could accept a hockey scholarship. 5 pages. In a few months, that young man would be legally able to play hockey. And one almost wants to laugh or smile about these decisions if they were not so profoundly serious. The judge obviously thought he was doing a good thing because he was deliberating in the young man's best interests. But surely, among a young man who is so exceptionally intelligent and highly motivated, could have made a decision about accepting a hockey scholarship. I want to tell you about another case. It's a mother with a 12-year-old child. The mother decided that the child would be allowed to go to an audition for a music scholarship. The child, in fact, won the audition. The father took the mother to court. He said that the mother had treated him like dirt and disregarded his views. The judge gave the mother a prison term, which he'd agreed to suspend. The mother took the case on appeal. The full court, in an extremely robust judgment where they incorporated much of the transcript of the Federal Circuit Court hearing so that the public could read it for themselves, condemned the decision and said the mother had done nothing wrong. Now, in all of these judgments, the primary judgment, the full court judgment, nobody at any stage thought to ask the child, did the child want to play music or not? Nowhere in any of those judgments does that appear to be a consideration at any stage. Now, of course, when we start to talk about domestic abuse, these cases become very distressing and very dangerous. So I want to tell you about a judgment concerning a young woman that I'm going to call Alex. And Alex was almost 15. By the time Alex's parents went to court, Alex's memories included her father holding a knife to her mother's throat, her mother being taken to hospital by the neighbours with a face that was bleeding and swollen and bruised. Alex, whenever her father was in proximity with her, began to have panic attacks. She hyperventilated, her heart raced. But the family court decided that even though Alex genuinely no longer wished to see her father, even though Alex was almost 15, that she still had to go into a child-inclusive mediation and a fully defended trial. Okay, because her father's claim to want to see her daughter outweighed what Alex wanted for herself. Now, in Alex's case, what happened is that the father failed to turn up to child-inclusive mediation, and then the father failed to turn up to the trial. So the judge once again didn't say that Alex could now make this decision for herself because she was an intelligent and reasonable person. But rather, the judge stepped in. He assessed what the father's views may have been had the father been there, because he wasn't. Okay. And he decided that ultimately it would not be in Alex's best interest to see her father, and did not compel her. I was talking to a lawyer just last week, and she'd been reading my book for many years. A good lawyer, you know, hashtag not all lawyers, not all judges. And she said to me, and she'd been for many years a children's lawyer, an independent children's lawyer, and is now a person in a different state, in a senior position in legal aid. And she said, Camilla, she said, there was a certain point in your book where I had to stop reading. She said, I felt I had to protect myself because of the kind of work that I do with children. And you sort of think, yes, no, it's very hard being a children's lawyer. But I did speak to another colleague of mine, another lawyer, and she said, oh my God. She said, but that's the very person who needs to read this book. And so the point where the children's lawyer gave up in the book, or so she told me last week, was another traumatic case where I think particularly everyone in Sydney will remember this case, and that is the murder of Jack and Jennifer Edwards by their father, 2 teenagers. Now, Jack and Jennifer Edwards, in no uncertain language, told the independent children's lawyer, told the court, the family report writer, told the psychiatrist they did not wish to see their father and why they did not wish to see their father. But if you read the inquest, you should read the inquest and weep, because in the inquest we read the documents and the court speculates, the legal actors speculate that the children's views were exaggerated, that the children were naming trivial things to be fearful of. We know the way that domestic abuse works is by controlling the minutiae of people's domestic lives in ways that perhaps to these people who ought to be specialists in this area appeared to be trivial and therefore exaggerated. Some of the documents concluded that the children were influenced by the mother. Now, influence, along with enmeshment, alignment, alienation, all of these words are always deployed in courtrooms to undermine children's stated views. In one of the many hearings where this matter came to court, the judge decided that the real problem was not the father. The real problem was not the fact that the father had been named on as a person of interest in more than a dozen apprehended violence orders. That he had a long history of domestic abuse spanning a number of families. He was the father of many, many children, many of whom he had not seen and did not wish to see him. Okay, but the judge decided that the problem, okay, was inadequate mothering. And this is the frame that we see constantly through these cases, that domestic abuse is reframed as problematic mothering. If a child does not wish to see their father, okay, it must be because the mother's not doing her job, because there must be something wrong with the mother. And if you've ever seen a family court trial in motion, you will know that there are gender stereotypes that have been argued in both directions. Okay, on one side, okay, the barrister argues the mother is the Madonna. No woman needs to be the Madonna to be a mother. Okay, on the other side, the barrister will be arguing that the mother is mad. Okay, and that approach, without being reductive, really does sum up a vast majority of trials, including domestic abuse cases, in fact, especially domestic abuse cases that go through the courts. So, in court, the judge blamed the mother. He decided the mother was greedy. It's all about money, isn't it, at the end of the day? Okay, he suggested that the mother should think seriously. He issued a veiled warning about contravention. The penalty for contravention is jail time, okay, to Olga Edwards. It's all about money at the end of the day. And then he turned his attention to the kids and he said, this idea that they can choose, is that what I'm hearing? Okay, and the independent children's lawyer, who was there to represent the children's views, as the independent children's lawyer said, if that's what the children are saying, then they don't get to say that. They're 12 and 14, they're kids. Okay, so somehow the views the children had expressed were views that they don't get to express, said the independent children's lawyer who was there to present the children's best interests. I think you know the end of the story, and I'm quite reluctant to go there, but had Jack and Jennifer been a few years older at the time of their murders, they would not have had to go through that. Okay. So, all of these cases, in a sense, they're different fact situations, but they're all in many ways culturally, ideologically quite similar. The sorts of ideas that Catharine was talking to you about earlier are the sorts of ideas that are guiding judges in talking about children and in making decisions for children. Okay, in common law areas outside the family court, the law has matured. In common law areas, it is recognised, for example, that a child has a right of access to medical treatment regardless of their children's views. I have children, I know at age 14 I can't get their immunisation history, and in fact with COVID I was finally able to convince the children that my son, that he had to open his own Medicare account and download his own immunisation certificate, okay, because once you're 14 those records are confidential. In many other areas of life, we recognise that children have shared decision-making, supported decision-making, and finally, autonomous decision-making. Nobody grows up all in a flash on their 18th birthday. And this is something that the family law, for a range of political reasons, all of which Catharine has articulated so wonderfully, doesn't seem to be able to go there, okay, because the culture is so profoundly paternalistic. Now, I just want to reiterate in wrapping up something that Catharine's already said and alluded to, and that is 97% of people in this country do not go to family court when they divorce. 16% of those people will use a mediator or even a lawyer to settle their disputes. The 3% of cases that end up in family court in this country are overwhelmingly domestic abuse cases. Up to 85% domestic abuse cases. This includes more than half featuring serious physical abuse and serious safety concerns, 85% emotional abuse. Financial abuse, there's no figures, okay? And as Catharine and I discuss at great length in the book, litigation abuse really fundamentally is a form of financial abuse, because the point there is not necessarily to win, but often to bankrupt the other party or to drive them into essentially a nervous breakdown. So, the Royal Commission on Institutional Responses to Child Sexual Abuse made some fantastic recommendations, but it did not investigate the family court. I just want to end with one point about the Royal Commission's findings. People don't tend to realise that society was only willing to listen to child victims of sexual abuse once they became adult survivors. And in family courts, I think it's time that we listen to children right now. Thanks.
So thanks to our two speakers. As you all know, we're discussing broken children, parents and family courts. So we get better. We'll go to questions and discussion. Those who are on the Zoom call have got advice earlier today about how to get a question through to me up the front here, which will be sent forward to me, and I'll read it out. And so we go to questions and discussion. So I get you both to come up here and sort of talk into the microphone. I think that's probably the best way to do it.
Okay, you go.
You? Okay, so I'll operate this part of the room and Anne will operate that part of the room. So just tell us, I know this is in your book, but in the 3% of cases that go to court, in a family court, what's the process? There's a breakup of a marriage or a partnership, there's some children involved of a certain age. What's the process all the way to the final court of appeal? What process is it?
Do you want to answer that?
Yes. So the process, as we all know, that with the amalgamation of the Federal Circuit and Family Court, the processes have changed just a little bit, although if you speak to anyone involved in the court, they will tell you it's more like a game of musical chairs, that people have got new titles, but nothing has really fundamentally changed. Okay, so when you file, okay, we now have a single entry point. Previously, there were multiple entry points. With the new regulations, you firstly need to go to at least attempt a form of mediation, say with the Relationships Australia. If you cannot resolve your conflict, you then enter the courtroom. Many cases, well, traditionally before the merger, which is extremely recent, would enter through the Federal Circuit Court. Cases would get transferred to the Family Court, the old Family Court of Australia, generally if they were high asset value cases. Okay, so 50% of the cases in the old Family Court were in fact property-only cases, big money, particularly in the Sydney registry, that took up a huge amount of the court's time. So unlike people who say, oh, the Family Court was a specialist court, I'm not sure. I would suggest to you the majority of domestic abuse cases were and have always been heard in the Federal Circuit Court since it was founded in 1999. Okay, you then go through a range of court management procedures, and at the very least, you'll go to an interim hearing, okay, followed by a final trial. If you read the annual reports of the courts, which don't contain that much information, in all honesty, more questions than answers in the numbers. The court says they try to resolve cases in 12 months. But what resolve means, you don't really know. It may in fact be that many parents went elsewhere, ran out of money, or something worse particularly happened. Very few of the cases are actually decided by judges, okay, and very few of the cases actually proceed to trial. It's a messy pathway. I mean, there's no easy answer. There may be a lot of interlocutory events or applications in a case. Once a case is active, you can make multiple applications in the one case. So, yeah, the long and the short, the very long, rather.
And can I just add to what Camilla's saying, as Camilla knows very well, when I was studying law, I graduated in 1988 at Sydney University Law School, which was very black letter. I remember asking at one point whether family law was an elective, being a bit of a lefty, I'm showing my colours here, and because I was interested in what Lionel Murphy had done. And I was told very firmly that that was not a black letter law topic. That was the kind of thing that women might choose to do if they decided to have children and do part-time. Now, in the interim as it emerges, family law, there are some family law practices which are hugely lucrative, particularly in the Sydney area. I live in the eastern suburbs, that kind of belt in Sydney. Some divorces, there are fees in the millions, and often, going back to the hearing process, often there are, it's very hard to get a hearing. They're delayed, and barristers charge disappointment fees. So there's a whole financial dimension to this too, which certainly didn't exist in the 80s.
Coming back to children, you're both saying that children are not heard, or not heard adequately. Who are they not heard by? I mean, who should be hearing children's cases in the process you've just set out?
Miller, do you want to?
The way children cannot speak directly to the court in Australia, I would suggest that sometimes speaking directly to the court or speaking directly to a judge can be just as artificial as any other process, really. Children are... a family report writer will be commissioned. Often that person will be a privately contracted, independent person that works for the court. The positions are largely unregulated. That person is usually assigned to listen to the children's views. The problem with that process, of course, is what that person is really listening to children's views is peripheral. The main thing is for them to conduct a forensic examination and make a sort of prejudge the child's views and decide if whether the child's lying or not lying or truthful or not truthful. It's not in the sense, it's not listening to the child's views in the sense that we'd understand as an adult that our views would be heard. If the case is a very difficult case, if it contains serious physical violence, for example, an independent children's lawyer will be appointed. Now, we know that not all independent children's lawyers meet with children, even though they are meant to under the court-endorsed guidelines. In fact, the majority of them just don't. Okay, they see their role as being forensic, that they're interested in fact gathering. So they will get the family report writer, they'll issue some subpoenas, and from that material they will infer what the child thinks, or rather give an assessment or prejudge again the child's views before they're presented to the court. The parents also will try in their affidavits to say, well, this is what the child thinks or believes. But once again, that's being filtered by what the parent thinks and what the parent believes. A child may, under the legislation, ask to see a judge, but judges are very, very rarely in this country ever meet with children. And there is nothing to compel a judge to meet with a child, even if the child's an older child, for example, requested it. So they're routinely denied. So that's the way a child's heard. I would suggest that they are all inadequate procedures for hearing a child.
It's rather depressing. Having looked at some of those decisions and the way in which things are argued by the justices that sit on the court, can you tell us a bit about the sort of judges that the court has? Because it seems to me that this seems, the way you've described it, it's probably the worst way to tackle family complications. I mean, family complications are not easily resolved even when you're not in court. They're always very complex. There's all sorts of undercurrents and issues going on. Firstly, what kind of background are these judges? What kind of training might they have had? And how can the judiciary do something about the problem?
I can go. I don't want to answer all the questions.
No, it's okay. There you go.
But I think the law is the worst possible instrument for dealing with these problems. These are not legally complex cases. They're just not legally complex cases, which makes the kinds of legal fees that get charged outrageous. Okay, these are emotionally complex cases. They're complex human problems. The law is quite simply the wrong instrument, although in our society, the way it's governed, it may in certain ways be the only instrument that we have. Okay, I think the adversarial system is the worst possible kind of law, or the worst possible method through which to hear these cases. You are asking parents essentially to dredge up all the worst things they can think of to say about each other in a law. Can you think how this escalates and ramps up situations that sometimes are already dangerous?
And can I just say the one thing I remember from law school is never go to court.
Yeah.
I mean, an inquisitorial system, but in fact what would be much better is a mediated system. And we know that, and we've introduced systems of mediation even in commercial situations. So I think the adversarial system, as you say, is the worst thing to do with the messy business of being human.
Stephen?
Catherine, before I get to my question, I should say, never have a child that you get to be a really good debater at school. You pay for it forever, so I sympathise with some of your earlier comments. Look, I'm in some ways lucky in that I've only had a single experience with the family court, which I think is good. And I have to say that the outcome of this eventually was also good in that the child psychiatrist made, in my view, a very good assessment of 3 young children, not in double-figure ages. And the judge made a very fair assessment. And I know that that assessment actually accorded with what both parents wanted going into the process. However, it became an extraordinarily expensive process because the lawyer for one party, probably somewhat a naive one party, convinced them that they had to make outrageous claims in order to make sure that they did well in front of the family court and that they needed to take the other party to court, not mediation. And the costs, you talked about costs outstripping assets in this case, absolutely, that was the outcome. So a bit like Camilla was talking about, outrageous costs and whatever, and giving a barrister to barrister, well, there's outrageous costs for a start. How can the family law court actually be made reasonable for parents cost-wise? Because, in this particular case, more was spent than would have been a great deposit on a property.
Well, I mean, I think Camilla can answer this in detail, but I mean, I would say that this is the whole point. I think, the family court, while it remains mired in an adversarial system, is going to be also mired in the kind of whole legal infrastructure that supports that adversarial system. We know that there's been a huge move towards mediation and conciliation, and these are much better designed systems. And I think anyone who's ever been to a therapist or a counsellor or family therapy, I can tell you, their approach is not adversarial. It's quite the opposite. It's trying to put yourself in the other person's shoes. And that's the opposite of what the court encourages. So while the court remains mired in the adversarial system, I think that's a huge problem. It's also hugely under-resourced.
Yeah, I think that, Patrick Parkinson, who's a Dean of Law up in Queensland, has long been trying to progress an idea for an inquisitorial system. The idea that cases would not be heard by judges, and if you've ever seen the Federal Circuit Court in motion, you would, I think, see that they're not necessarily the best people to be handling any of these cases, but rather would be heard by a panel of experts where you have, yes, a senior lawyer, but a psychologist and a social science professional who is across the fundamental issues of the case. So many of these cases can involve things like drug addiction, alcohol addiction, mental health issues. There can be a whole array of complications. So if you have a multidisciplinary panel, you have an inquisitorial system, which means that the hearing is led from the bench, okay, from the panel, okay, not by the parties' lawyers. I think that restraints need to be put on lawyers, and as much as I say hashtag not all lawyers, I also think that you're not dealing with the situation if you do not look at the private money-getting entrepreneurial ventures of lawyers and how that fuels acrimony in the family courts. You need to look at the profit motives in a lot of these organisations that make money out of the court. Otherwise, you're not looking at the system.
Yes, the question there. Speak into the microphone.
I have given up practicing family law, but did practice over 40 years. I can tell you...
Don't sue us.
Can I survive? But I haven't done it for the last few years. So I will say this, it comes from both sides. The difficulty is, and I can tell you, I sat next to on a bus one day with the former Chief Justice and said, I personally would never be a litigant if I could ever help it in my life, in any court. And of course he thought it was wonderful, that's true. You're dealing with people, as you said, that 3% adults who can't, as adults, make decisions that are best not just for their children, but for themselves. This is the intractable part of what we're dealing with. And I can tell you, you will say there are lawyers who charge and whatever. You also can't control what the other side will do. You can't control it's very difficult even to control your own client. Don't be a little bit too simplistic about it. It's not quite as simple as you would hope. And I would say this, I do know some children's representatives who have been excellent and tried their very, very best to put to the court what is in the children's interest, which certainly may not be in either parent's interest.
Okay.
And I can say every Saturday, I'd say no 14-year-old wants to be with any parent, let alone
okay.
friends.
So I guess the question is, if individuals are like that, as like the questioner says, would mediation make any difference? Because presumably, if that's how 3% of people behave, they'd behave that way before a court or before a mediator. Is that correct or not correct?
Yeah, which is why having an inquisitorial for cases that aren't going to mediate. And I think that, I think a lot more can be done in that space than is currently done. But for cases that won't settle at mediation or arbitration or any of those sorts of possibilities, then I think an inquisitorial system will deal with cases far more swiftly. And also remember, 40% of cases before the courts, one or both parents will be self-represented, okay, because they cannot afford a lawyer. This is also, so you have a system that's designed for lawyers in which almost half now, 40% of litigants will need to self-represent, or at least one or both parties in 40% of cases will be self-represented. But of course, what our book is trying to do is to centre the children. Firstly, we want to look at this is a structural problem. It's a problem of the system. Okay, you can't control what people do, but you can, in fact, structure a system that does a better job than the one that we have. And also, you can put the children front and centre.
Just before I go to the next question, but if 40% are not represented, they're not paying any legal costs, so they can make as many demands as they like, because the other 40% have got to carry the cost.
Yeah. Yeah.
So, and that can become a serious... I mean, if you've got legal aid or no aid, you go into court and someone's got a lawyer, that party's paying all the money and you can go on forever. Is that right?
Yeah, no, that's perfectly true. And your costs may be driven by the other side. So in those sorts of cases, absolutely. But also there are great dangers when you go into court. In the story I told you about the music audition, what I had omitted in telling that story was that the mother, who'd been paying lawyers all along, decided, well, this was something easy that she could handle. And for the first time she thought, I'm just going to represent myself because I don't have the money to keep paying. Okay, and that's how she ended up with a prison term. So it can be very dangerous.
Yeah. I mean, you mentioned a custodial,
a suspended prison sentence, but it's still a conviction, and it still would have a terrible impact on her capacity to find employment and earn a gainful income.
Before we go to the next question, do you want to comment on that?
No.
Okay, so it's down there. Speaking in the microphone, okay?
I suppose the question I'd be asking is, you must have picked up in your research for this a sense of what children can cope with and at what age they start to be, they can still be influenced, at what age they are completely able to make a clear determination on their own, what their future looks like with either parent. So could we talk a bit more about that? Could you give us a sense of what you found out about the children in all your research?
Catherine, you do this one. It's a favourite of Catherine's.
Well, I've done quite a lot of research, mainly with teenagers, because ethics committees at universities will not let you do any research with children, which is another reflection of the idea that you can't really talk to children. But one of the interesting things, I think the first thing to say, and any good person who works in child development and psychology will tell you that, all of us mature at different rates. Some of us are still growing ourselves up, like myself. Some of us are quite wise at the age of 7. So, I mean, the term age appropriate, it sounds like a bit of get out of jail free term, but this is why, going back to the inquisitorial model, having people who are able to assess and understand children's capacity and agency, and you're going to have children who are very articulate, and you're going to have children who are quite introverted, and if a child's been witness to or the victim of, survivor of abuse, they may in fact be very intimidated and silenced in the first place. So that's why I think you need this kind of broad expertise to make those sorts of assessments. And I think the reality is, nothing against judges, and I know there are very many well-intentioned lawyers and judges and people who are appointed to speak for children and to report back on children to the court. I don't doubt the intentions in many cases. But the reality is these people are not trained. This is, coming back to the point of this is a very messy, emotional area of human life, which is it's not commercial law. It's not two companies fighting. So, and it's funny, I was talking to a woman who works with me in a consultancy I have, a brilliant young woman, and who comes from a very wealthy background. And we were talking about trauma, and she said, my parents went through the family court and she left it at that. Mm. She's now in her 20s, but, she said, I will never get over that.
Okay, just before we go, I haven't missed anyone, have I? So you've got final comment? We're right on time. Yeah, we're right on time, so we've just got to go very quick. Final comment. Any solution? I mean, what would you do initially to resolve the issue? A very quick response. I mean, if you could resolve it, what would be the first move?
Oh, resurrect Lionel Murphy. I'm just saying that to wind you up, Gerard.
I'm going to let Catherine have the last word on that.
Bring back the Whitlam government? No, I think we've had a lot of inquiries. The problem, as Camilla writes very eloquently in the book, is so many of them are gathering dust. And the Australian Law Reform Commission wrote the most recent and comprehensive report. The problem is it's not the want of inquiries or reports or good, well-intentioned lawyers or judges or anyone in public policy. It is the fact that it is a political issue and it seems to be intractable. I hate to sound pessimistic.
Yes, so on that note, for a quick answer, you could implement the recommendations of the Australian Law Reform Commission inquiry.
Yeah.
There we are, folks. It's easy.
Oh, good, that's done.
We fix it at the Sydney Institute, we always do. No, we're right on time, and we always finish right on time. So many thanks to Camilla Nelson and Catharine Lumby for Broken, Children's Parents and Family Court, and the discussion on that tonight. And there'll be the reforms here, but also we'll be selling the book online, and our authors will sign it. But for tonight, it's been I think one of the important things about this book is a lot of good case studies, and it's always easy to understand matters if you've got case studies rather than just theoretical comments, and there are many case studies, some of which are very sad. But for tonight, thanks for a lively discussion and an important contribution to Catharine and Camilla. Thank you.